Hello everyone, thank you for joining us for our seminar on particulars of claim in possession cases and really possession cases generally. My name is Sam Davis and I'm sat here with Krishma Patel, 42 Bedford Road. We both deal with possession cases and property law generally, as well as some other things in our practices. This is going to be quite a high level seminar, just touching on the pre-action stages, what you should be thinking of when you're preparing a possession claim, when you're approaching a possession claim, and then how you should approach the particular claim in particular and actually launching that claim at court. And so I think we'll slip straight into it. Is that okay, Krishma? Is there anything you want to say?
Sounds good to me. No, that sounds good to me. I'll move on to the next slide. There we are.
Brilliant. So you can see the first slide, we're looking at basic requirements of a possession claim. Obviously, one of the first things you're going to want to do is look at the tenancy agreement. If there is a tenancy agreement, that may not be a tenancy agreement, but if there is a tenancy agreement, look at it and try and identify what sort of tenancy you're looking at here. We're going to talk about some of the types of tenancy in a moment. But is it, for example, an assured short-hold tenancy? Is it a secure tenancy? Are you looking at a non-tenancy case where there's a trespasser? Is it a case where someone just come and occupied the property? Is it a case where there was a tenancy agreement and that's now ended? Potentially somebody's parent has died and there's a child trying to raise a right of succession that doesn't exist. So now they're just there potentially as a trespasser with no actual legal right. Are we looking at an excluded license or some other form of occupational right? Once you've identified the type of tenancy agreement and the type of tenancy, well, then you can start to explore what sort of grounds you're going to be looking at. You're instructed to seek possession. So how are you going to try and get possession of this property? Well, if it's trespasser or there's no tenancy agreement, you're going to be looking at reasonably straightforward grounds to try and advance the claim upon. But if there is a tenancy agreement, depending on the type of tenancy, you're going to potentially be looking at different categories to drop the claim into. And obviously, infamously, what we're all very aware of is Schedule 2 of the Housing Act 1988 with its discretionary and mandatory grounds. And we're going to talk about those in a bit more detail, but it's important you've identified the tenancy and you've also identified the ground or basis of your potential claim. Once you've got that, then you're going to be looking at notice, which we'll deal with in a bit more detail in a moment. And then, of course, once you've said the notice, you've engaged with the tenant, and you're going to be looking at issuing the claim in the county court in accordance with Part 55 of the Civil Procedure Rules. So, Krishma, do you want to talk about determining the type of tenancy, or have I already dealt with that?
Yeah, no, let's, so we've got a slide on this. So, bit of a basic slide, but just some pointers to kind of help with looking at the agreement. Most of the agreements will outline things like the length of the tenancy, which will tell you whether it's fixed term or periodic. For example, does it run month to month? Does it run week to week? It'll tell you something about the rent amount payable and how often it must be paid. It may say what bills or services are included in the rent, and it may also say may also have some clauses or terms within said tenancy that explain how the tenancy can be ended and who's actually responsible for repairs, maintenance and safety. And that can be quite important, where, for instance, the tenant is thinking about a counterclaim in terms of disrepair, something that we'll come on to in a few more slides. So those are a few pointers about how to determine the type of tenancy, having looked at the agreement. What do you think, Sam, is the most common form of tenancy?
Well, I think there is a slide on this if we leap to the next one, which is designed to indicate that we at 42 Bedford Road think that there is one type of tenancy that's more commonly along, which is the assured short-hold tenancy. Whether that is factually the case, I do not know, but certainly in my practice, I mostly encounter assured short-hold tenancy disputes. Yeah. And you see that we say there on our slide that we think that is certainly one of the most common forms of tenancy, if not the most common form at the moment. Most new tenancies are, of course, automatically of this type. We set out in a few bullet points there some things to look for if you're trying to query whether it is in fact or is not an assured short-hold tenancy. There are some other ones that we should be aware of. I think they're covered on the next slide, aren't there?
They are. Let's have a quick look. So we've got, for instance, assured tenancies. So those are ones that start between January 15th of Jan 89 and Feb 1997, they may be assured. And with those, tenants have increased protection from eviction with that type of agreement. You've also got non-assured tenancies. They can only be used in particular situations. So, for example, where an assured short-haul tenancy can't be used, so that may be, for example, where the rent is less than £250 a year, or the tenant has their main home elsewhere, or you live in the same property as your tenant, as long as you don't share the facilities. There are also regulated tenancies, second bullet point up there. Again, these are tenancies starting before the 15th of January 1989. They may be regulated, and effectively, they mean that the tenants have increased protection from eviction, and they can apply for a fair rent, which is set effectively by the Evaluation Office Agency. And then finally, we've got excluded tenancies or licenses. This is where you've got a lodger, for example, living in your home, you're sharing rooms with them, like a kitchen or a bathroom, and it usually gives your lodger less protection from eviction than other types of agreement. And you've also got on there council tenancies. So we often see these types of tenancies with social housing situations. Whilst we say, in terms of the work that we do, that the most common is an assured short-hold tenancy, there are indeed other tenancies and types that exist, which is why we draw your attention to looking into the type of agreement to try and decipher what type of tenancy there is at play. The next thing that we want to talk about are notices.
Yes, I think we have a slide there as well. I
We
think I'm
do
going to talk a bit
We do.
about
It doesn't have much on it, but we're going to talk about it in more
two
detail.
notices on this particular slide: Section 21 notices and Section 8 notices, and there is all that is on the side. Of course, that is not the be-all and end-all when it comes to potential possession notices. There are a plethora of potential notices out there that you might need to draw upon. I'm not going to just list them all out for you, but we're looking at introductory tenancies. You may be using, of course, the notice that's suitable for that. If we're looking at a potential secure tenancy, you could be looking at a Section 83 notice under the secure tenancy regulations. The key thing to do is to identify, once you've identified what the tenancy is, to determine what the correct notice is. And then if you're proceeding with a possession claim or you're going to try and obtain possession, you of course need to serve that notice upon the potential defendant, the tenant. Service is essential. And you should be sure to make sure you've got evidence of service. You do not want to be at court down the line trying to evidence service or prove that you served the notice properly when you didn't acquire contemporaneous evidence at the time of actual service. So make sure you've got that evidence of service. When it comes to those two main types of notices, we'd always suggest you look to Form 6A in relation to Section 21. And of course, Section 8, we're going to be using the infamous Form number 3. And you have to use that one, whereas with Section 21, you've got a bit more flexibility. And when it comes to notices, it's really important, we think, that you take every step to make sure they're as accurate as possible at the outset. Too many claims founder or become extended or adjourned or far more difficult because of errors on the notice. Make sure the name is correct, for example. Make sure the address is correct. Make sure that you're setting the right date for when the notice should end. Make sure your client's name is correct. Make sure the notice is signed properly if it needs to be signed. Small errors cause huge problems down the line, as I'm sure you're all aware of. Then I think what we were going to leap into is grounds of possession, the mandatory and discretionary grounds. What I would note, though, just alongside notices, if that's okay, Krishma, is of course, it's not just a matter of identifying that the client wants possession and then just firing off a notice at the potential defendant, at the tenant. You should also engage with the tenant around that. And it's important to be aware of the pre-action protocols, especially if you're a social landlord, and make sure that you are trying to correspond with the tenant, explaining to them really what it is that's gone wrong. And if it is potentially curable, if it's rent arrears, for example, talking them through how they might cure that, be able to show the court you did engage properly. If it's not curable, if things have gone too far, we're talking about antisocial behaviour or other potential breaches, make sure you're explaining that to the tenant, make sure you are engaging with them properly, and then also be sending that notice in to them. If you're a social landlord, of course, and you're looking at rent arrears, there is a real burden upon you or your client when it comes to rent arrears. You need to be helping them engage with potentially the Department for Work and Pensions. You need to be trying to assist them in finding a way through their current problems. So then on to grounds of possession. Sorry to go off on that tangent.
No, not at all. And actually, I was going to say, just off the back of what you've just said, Sam, given that Section 8 notices and Section 21 notices are served for different reasons and they're completely independent, I've come across cases where you can serve them both at the same time, and then the tenant would need to take steps differently in relation to each of those. I don't know, have you come across cases where they've been served, whether there's been a Section 8 and a Section 21 at the same time?
I have seen that, yes,
Yeah.
and I've seen those where they can't be served without prejudice to each other.
Yeah, I'm of exactly the same view. I'll move on now to grounds of possession.
I think I was going to take the mandatory grounds.
You were.
Well, here we are. Well, here is slide 7. It outlines what we're just about to talk about. I think we've already, summarising quick Tracy, the point here, which is if you're looking at a standard possession process, if you're looking at a tenancy agreement, you're probably going to need to fit it into a box, a ground to justify your possession claim to get home when you actually come before the court. As if we jump to the next slide, we'll be dealing with the mandatory grounds. The common ones are set out, main ones, if we're looking at an AST claim, set out in Schedule 2 of the Housing Act 1988. And the point of a mandatory ground, of course, is if you prove it, the judge has to order possession. They don't have any underlying discretion there. And there are a number of mandatory grounds. I'm not just going to list them to you. It's worth looking back to Schedule 2 and reminding yourself of what they all are. A lot of them are prior notice-based grounds, owner occupation, or whether it's a holiday let, where you've given that prior notice at the time that the tenancy started, and now you're exercising that right following on from that notice. The main ones really that crop up in certainly my practice, I don't know if Krishma's practice also affects this, antisocial behaviour and rent arrears.
Yeah.
Do you see a lot of that?
I would say that they're probably the two most common ones that do come up, actually.
Yes. Yeah. Death of the tenant also occasionally causes problems, but I absolutely agree. Antisocial behaviour and rent arrears are what we're looking at most of the time. And of course, with the rent arrears mandatory ground, you're aiming or hoping that the rent arrears are still outstanding on the day of the trial. It's quite an easy ground to defeat if the tenant just pays off the arrears. So if you're going to go down that road without going through that particular ground in great detail in this particular seminar, it's always worth, if there are rent arrears, pleading some of the discretionary grounds as well. I know Krishma's going to go on to in a minute. With antisocial behaviour, that is being used more and more, and certainly I'm seeing it more and more. It's a reasonably complex ground. There's a number of categories you might be able to, subcategories you might be able to bring the claim into underneath it. Has there been a conviction for a serious offence, for example? Is there a breach of a criminal behaviour order? Has there been a closure order? Is there noise nuisance? Really look at it carefully and see where you might fit the claim that you're looking at. Can you fit it into multiple categories or subcategories? If you can, plead all of those subcategories. Just be aware that you're going to have to prove all of them. Krishma, I think discretionary grounds, unless you have anything you want to say.
No, I think you've covered it really well, actually, Sam. So discretionary grounds also found within Schedule 2 of the Housing Act 1988. I'd invite you to just have a look over those. They run from grounds 9 to 17. Those are the discretionary grounds. Again, I'm not going to run through all of them, but by way of an example, ground 9 relates to suitable alternative accommodation. So for that ground, you need 2 months of notice of proceedings. There needs to be suitable alternative accommodation for the tenant, either available or to be available when the court order takes effect. And if the court is satisfied that the alternative accommodation is suitable, it must also consider whether it's reasonable to award possession. And that's an example of one of the discretionary grounds, and that's ground 9. There again, they run from 9 to 17. They cover a variety of situations, but the one thing I would point out is ground 14A relates to domestic violence. And that ground actually only applies to assured tenancies granted by private registered providers of social housing. So that's just one thing to bear in mind in terms of the discretionary grounds and the ability to use those. Of course, in terms of discretionary grounds, the court has wide powers in relation to these grounds. So if a landlord is using any of these grounds to rely upon, it has to be reasonable for the court to grant possession. And the court does also have, again, as I've said, wide powers. The court can adjourn cases involving discretionary grounds. In terms of what the meaning is of reasonable in possession proceedings, it means having regard to both the interests of the parties concerned and also the public interests. And in terms of determining whether or not it's reasonable to order possession based on one of the discretionary grounds, a number of factors can be taken into account. So those can include things like the reason for, the seriousness of the breach, whether the tenant has had an opportunity to remedy that breach, whether the breach has in fact, for instance, been remedied, and the effect of the tenant's conduct on others, the consequence of eviction for this particular tenant and or their family, and whether there have been any further breaches occurred in the run-up to the trial or the hearing. So those are all factors to bear in mind, and it's important, I think, to be ready to justify why, if you're bringing a claim for possession on the basis of a discretionary ground, it is reasonable for the court to grant that order. I will flip to the next slide, which is defences.
Let's take it straight to there. I think that's back to me. A reasonably meaty subject. And repeat what we've been saying on the previous slides. I'm not going to run through lists of potential defences. The answer is that there's a myriad of them, and they run from quite limited options for a defendant when you're looking at a private Section 21 claim, through to multiple potential options when you've got a social land or client or a local authority. The sorts of defences that might be raised then might be much broader. You should, when you're preparing claims, certainly when you're looking even at the notice stage or the pre-action stage, expect to defend it. You may not expect the defendant to defend it, even, apologies. You may not have to fight defence. They may not contest the claim. They may not even contest the notice. They may leave willingly. But it's much better at the earliest stage for you to be turning your mind to potential defences and things that might go wrong down the line. Now, the first one we've outlined on this slide is potentially the most obvious one, which is turning up at court and then not being able to prove the grounds that you predicated your claim upon. And I don't think I need to spend a lot of time on that. Look at the grounds, see what you base the claim upon, make sure you've got evidence that's going to support those grounds. If you don't, the court isn't going to make an order simply because you asked it to. And of course, if you can't make out your grounds, you can't prove them to the required standard, the claim is going to sadly fall on its face. We then flagged some other bullet points. We've got the Equality Act, defects to the notice, public law defences and counterclaims. I'm going to take them in a slightly different order. First of all, just on defects in the notice, what I might call technical defences, extraordinarily common in all possession claims. If the defendant wants to, or the tenant wants to fight back, they're going to look for defects and technical defences. It's an easy way for them to push back and cause issues, and you need to be ready for that. And the best way to be ready for it is to make sure that at each stage you're getting everything right, really. You have to remember that housing judges often deal with an enormous number of these cases every single day and every single week. They're very familiar with the notices, they're very familiar with the law and the requirements, and they're going to likely notice or spot if something has gone wrong. I outlined at the beginning, or a few slides ago certainly, the real basics, making sure you've got your name right, the landlord's name right, the correct dates on the notice. It is right that to a certain extent, the nature of the defect and the extent to which it undermines the notice itself will change the court's response. So recent authorities have started to underline the reasonable recipient test. Effectively, if the tenant can clearly understand what the notice is meant to be driving at, and it's obvious that it's just a typo, and that typo is, well, it's easy to understand what the typo is meant to say, then you might well be able to get around a defect. But you don't want to be having that argument in the first place. And some defects may not fall within the bounds of the reasonable recipient test. So if the statute, the relevant statute, clearly says the notice must include X or Y, or the notice must state X or Y, and then you have not complied with that, you're going to be running a much more difficult argument about whether the notice has substantially the same effect, and you may not be able to run that argument. You may need to reserve the notice, reserve the claim. So best to avoid that in the first instance and try and avoid defects in the notice or technical defences. When you're looking at technical defences, it's also worth remembering the requirements of the CPR. So have you complied with the pre-action protocols? Have you done what the procedural rules require you to do? If not, go back and make sure you are doing them, otherwise you may face a technical defence on those points. Another point that comes up slightly more rarely, but just bear in mind that under the CPR, the claim form has to be served a certain number of days before the matter comes before the court. Now, you may think, why would I be worried about that? My clients are much more concerned about getting a hearing this year than accidentally getting a hearing within 28 days of service of the claim form and being in breach of CPR 55.5. But actually, what I would flag in relation to that particular defence and issue, just to potentially focusing on one of them, is a lot of claimant landlords rely on the court to serve the claim form. And whilst the court is not listing hearings very quickly at the moment, in fact, time seems to be running longer and longer between hearing, well, certainly issue the claim form and then actually getting the hearing listed. What you're also starting to see, or we're certainly starting to see, is the court being much slower in serving documents or not serving documents at all. So if you say to the court, please serve this claim form, sometimes they won't serve it, or they'll serve it in an unsealed form, or they'll serve it within that 28-day band. And suddenly, even though you issued the claim 6 months ago, you're going to turn up at court and find out that CPR 55.5 is in play, the tenant only received the claim form 2 weeks ago, and actually the hearing has to potentially be adjourned, or you've got to make an application to shorten the time period for compliance. Just in relation to that particular defence, an obvious way forwards is to ask the court to serve the claim form, and then also to serve it yourself and have evidence of service. You will circumvent it. But it's an example of a technical defence that you just need to be alive to, and there are a lot of these technical defences. So be aware of the procedural rules, be aware of the notice requirements, try to the best of your ability to make sure that you are hitting those points. Then counterclaims are rarely a defence to a claim that is not predicated on rent arrears. So if you've got a rent arrear claim, then you may well see a counterclaim to try and defeat the actual possession claim. The obvious example that we all see a lot is a disrepair claim. Something's gone wrong with the property, landlord's breached its obligations, and they're seeking a damages award to set off against the rent arrears, either to get them below that mandatory Section 8 threshold, or to reduce them completely so that there's no real arrears that can be relied upon. There's nothing you can do really to prevent that when you come round to drafting and preparing a possession claim. Be alive to it, and if the defendant does raise that sort of counterclaim, obviously defend it, respond to it, engage with it. If the claim isn't predicated upon rent arrears, a counterclaim may not be able to defeat the claim for possession, but it may well defeat any money judgment sought in relation to outstanding arrears alongside a non-rent arrear ground. So if you seek possession on the basis of antisocial behaviour, but there are also some small rent arrears, you may still face a counterclaim to try and reduce those rent arrears down. You may just face a counterclaim just for damages because the tenant doesn't want to be evicted, or because they have a good claim. It's always missed sometimes. If the tenant does have a good claim, there's no reason why they're not going to bring it to try and seek an award. So just be alive to it and respond to it. And then we've also flagged Quality Act offences and public sector defences or public law defences. With the Equality Act, I'll touch on it very briefly. At the earliest possible stage, be identifying whether protective characteristics are in play, whether there is going to be a need to take account of those protective characteristics and justify your client's actions. Obviously, if you've got a social landlord, be much more alive to that and make sure that they have done any required assessments. And then on the public law side, that they flow into each other to a certain extent. Again, be aware of the obvious pitfalls. Does the client have a policy? Have they followed that policy? If they have not followed their own policy, why not? Can you justify it? Is the Public Sector Equality Act duty engaged? Well, certainly if they're a local authority or a social landlord. Have they done the required assessments? Are they clear that what the steps they're taking now are reasonable, proportionate and necessary? Are we looking at antisocial behaviour or rent arrears? If not, how are we going to justify this possession claim?
Just touching upon your point about counterclaims, of course, there are a variety of counterclaims that can be brought. We touch upon the ones that are frequently brought, or the most usual, if I can put it like that. But if the tenant, if they were bringing a counterclaim in terms of disrepair under Section 11 of the Landlord and Tenant Act 1985, they need to show deterioration of the condition of the property and or item, and that the landlord has notice of it. And the damages are normally awarded as a percentage of rent. So if there is a very significant degree of disrepair, it could potentially have the effect of reducing the damages claimed for rent arrears, for example, if that's the ground relied on for possession, or extinguishing it. So it's important to bear in mind the ability of the tenant to bring a counterclaim, and the fact that counterclaim may be brought even as late as the first hearing, which would then result in potentially an adjournment and then directions for the tenant to then file a defence to then take that point further. On to the next slide, which is CPR 55. So this is more about the formalities and the things that need to be included in the particulars of claim. So the first thing to say is that the particulars of claim must be filed and served with the claim form, and that's set out in CPR 55.4. And then there are, I'd invite you to, if you're in a position where you're drafting particulars of claim for a possession claim, have a look at Practice Direction 55A. It sets out what is required specifically in a possession claim. So 2.1 says that the particulars of claim must identify the land to which the claim relates. It must state whether that claim relates to residential property, state the ground on which possession is claimed, and give full details about any mortgage or tenancy agreement, as well as details of any person, or every person, sorry, I should say, who, to the best of the claimant's knowledge, is in actual possession of the property. Now, those requirements those details, do need to be in the particulars of claim. There are also additional requirements, which it is worth drawing attention to, that are set out in paragraph 2.2 of Practice Direction 55A, and they effectively they apply to residential property that's let on a tenancy, and the additional requirements are set out in paragraphs 2.3 to 2.4b of Practice Direction 55A. And effectively, they apply if a claim includes the non-payment of rent. Now, since this is a ground that both Sam and I come across very regularly, we thought it'd simply be worth drawing your attention to it and setting this out. So if there is a claim that includes the non-payment of rent, in that situation, the particulars of claim do need to set out the amount that's due at the start of the proceedings. They also need to set out in a schedule the dates and amounts of all payments due and payments made for a period of 2 years preceding the date of issue, or if the first date of default was less than 2 years before the date of issue, then from the first date of default, and a running total of the arrears. 3, they need to set out the daily rate of any rent and interest. 4, any steps taken to recover the arrears of rent with full details of court proceedings. 5, any relevant information about the defendant's circumstances in particular, including whether the defendant is in receipt of social security benefits and whether any payments are made on his behalf directly to the claimant under the Social Security Controllers and Benefits Act. The other point to mention is if the claimant does want to rely on a history of arrears that is longer than 2 years, then that should be stated specifically within the particulars, and there should be an exhibit that supports what is effectively pleaded in respect of the particulars of claim if it goes longer than 2 years. There are also requirements relating to if the claimant knows any person, including a mortgagee, that's entitled to claim relief against forfeiture, then that needs to be set out. So the particulars of claim must state the name and address of that person, and the claimant must file a copy of the particulars of claim for service upon them. So that's effectively a slightly niche point because it deals with possessions based on mortgages, but it's important to bear that provision in mind also. I don't know if there's anything else, Sam, that you would think is worth pointing out in terms of CPR 55 or the practice directions therein.
I think only, Krishma, probably paragraph 1.5 of practice direction 55A, which just, I think, underlines a point that's generally known and accepted, so I won't labour it, that you must use the appropriate claim form and indeed the appropriate particulars of claim form if you fall within any of the relevant categories. And so do look at practice direction 4 and look at the forms that are provided and specified for the particular claim and indeed the claim form. And if they're relevant to your case, and probably will be, make sure you are using those forms. If you're not using the correct particulars of claim form, make sure you've got a good reason why not, and that you can justify it if asked. That's anything I would add.
Absolutely. We have put in a slide about practical pointers, but actually I think what we've been doing is giving practical pointers along the way.
Exactly.
In summary, I think I can safely say for the both of us, make sure you're using the right forms, pay significant regard to practice direction 55A and CPR 55 in general, both relating to the form and content of particulars of claim, as well as the provisions relating to service. It's important to make sure in particular that notices are correct, both procedurally and also in terms of the content of said notices, because they can cause issues further down the line if the tenant does raise concerns with the notice. And it's also important to be alive to potential defences that may be brought even at a very late stage. Is there anything else that you'd add to that?
I don't think, no, not at this stage. I think the next slide gives our contact details. And
It does.
all I
It
would
does.
probably emphasize is this is quite a high level seminar. Thank you very much for your time. But if you do have any particular cases or any more focused questions or queries, don't hesitate to get in touch. We're always here. And when we're not in court, we're very happy to discuss your case or query or concern.
Absolutely, and just to echo what Sam said, please do email us if you need to, and thank you very, very much for joining us today. We're really grateful. We hope it's been a useful webinar for you.